take you through what to expect in this course. Okay. Well, I'll take you through the course outline, what to expect. And today we'll focus on Unit 1. There's one issue that I think I discussed with your class captain. Tomorrow's lecture actually conflicts with another lecture that I have. So we'll have to, at the end of this class, reschedule another date. Maybe tomorrow after 12 or so, if the class is free, we can do I think it's 10:30 to 11:30 lecture. We can do that. Okay. Before I start taking you through the course outline, is there any question or any concern that anyone wants to raise? And this class is going to be a little bit interactive. I'll have to get feedback from you. It shouldn't be a class whereby you just put your phone somewhere, because I'll be calling up and I'm calling names for you to answer questions. So kindly pay attention. But before I commence, is there any question that anyone wants to ask? Okay. Feel free to interject, and if you have a concern or anything, just voice it out. Okay. So I'll take you through the course outline. Okay. And even before I even go to the course outline, if you look at the model or the handbook, there are some reading lists that you will have to, not all of them, but if you can read some of them, it will help you very much in this course. Okay, so as is a law course, we'll be dealing with two parts. We're looking at the first part of this course will be dedicated to international law, so things that happens in the international sphere. Okay, and the other part will be coming down to Ghana to look at our laws here and how they relate to conflict management. So conflicts, they can arise in the international sphere, or it can be in the domestic kind of arena. There must be laws that will deal with it. I think last year or so we dealt with law and society, so you know a little bit about law, but there will be some revision on what law is and the rest. Okay, so some of the reading lists are, the 1982 Constitution of Ghana is a must. You must at least download it, have it on your phone, and know a thing or two about the Constitution. There is a S.A. Brobe, Practice and Procedure in Trial Courts in Ghana. That book is more geared towards law students. And geared towards the professional part of law. It tells you which court to send which cases to.
Sir, okay. Please, which book are you talking about?
S.A. Brobe, Practice and Procedure in Trial Courts and Tribunals of Ghana.
S.A.
Brobe. It's in your reading list, so you don't have to copy it down. Just go to your reading. It's in your manual.
Yes, sir.
So you can have a look at it. You don't have to write it down. So S.A. Brobe is about trials and procedures. So it tells you about if it's a criminal trial, what you have to go through before you get to finality. It tells you about civil trials and filing of writs and all of those things. Okay, that is more geared towards law students, but you can use it, kind of skim through it to get certain things. Okay, then there are books like Birchall, White, and Morris. All of those things. It talks about international law essays, in memory of Hilaire Macabre. Then there's the law of armed conflict. Okay, international law on armed conflict. There is a Mensa Bonsu Annotated Criminal Offences Act. The latter part of our class will be on specific offences related to conflict management. Okay. And there are different other books that you can have access to. There is a Kwanzaa EK, the Ghana legal system. It tells you about our legal system in Ghana here. There is a book that I'll provide you with a soft copy that it can give you an extra reading on the law of international armed conflict. That's Colby and Hyde. Okay, I have the soft copy and I'll provide it to you. Okay, but don't limit yourself to just the books I have provided here. You can read around this area. It's a topical area. International, public international law. There are so many books on it. You can, if you want to do extra reading. Okay. Any question on the reading list? Okay. So let me quickly take you through the outline, okay, which you have in your model. Okay. So today we'll be looking at units 1. Okay. Unit 1 is basically an introduction. That's what I'm doing here. And we'll look at the introduction to the law related to conflict management. We'll distinguish between what is public international law and what is private international law. Okay. Then we'll look at international law of armed conflict as a branch of public international law. Okay. We'll look at the historical evolution of the law of armed conflict. When we say the law of armed conflict, what do we mean? Okay. Some people are philosophers, Carlos von Clausewitz and co, who state that when you are at war, there shouldn't be any law. War should be the fittest must be able to conquer the weakest, and there shouldn't be any laws that regulates war. It's even kind of a contradiction to say that law must govern the way wars are waged. Okay. So we'll be looking at some of these things, and we'll look at the evolution of the historical evolution of the law of armed conflict. How come human beings decided that we should have a way of solving our conflict? It should be through dialogue and kind of legal other soft means. But there are certain times that it becomes inevitable to engage in war. Whilst we are engaging in those wars, there must be some rules and regulations with respect to the way the wars are waged. And that is what we refer to as the law of armed conflicts. We'll look at some of the basic principles that are applicable to the law of armed conflicts. Okay. So that's for unit 1. Unit 2, we'll be looking at introduction and also jus ad bellum. Okay. That is the right to wage war. Okay. It's inherent in any society to be able to use force to achieve whatever means that you want to. You can use force to achieve the acquisition of natural resources, to to acquire cheap labor to work for you, and all of those things. Okay, so long as you have the means to do it, jus ad bellum allows you as a state to engage in war. And in modern times or in current times, people will talk about things to do with the Israeli Arab conflict, the Russian and the Ukraine kind of war, Trump's threat to take over Greenland, and all of those things. The argument would be that so long as America has the power, it can do that. It can go and acquire Greenland through force or through whatever means, and the end actually justifies the means. The Chinese too have their own issues with Taiwan and all of those things. And so long as, power is might, so long as you have the arms to capture your enemy, you can use your enemy to fight your wars for you, or can use your enemy's resources at your disposal. So instead of building diplomatic kind of channels to resolve conflict issues, all you have to do is build up huge arms and get your opponents to comply to your needs. Okay. So we'll be looking at some of these components of this jus ad bellum thing, and the fact that it used to be the case that, so long as your army is big enough, you can actually go ahead and capture other people. But with civilization and as time has gone on, we've realized that it can lead to so much atrocities. We saw it in the First World War, Second World War, and even just recently in this Israeli-Gaza war where human lives were being lost. Okay. So the law of armed conflict will come in there to monitor and also to protect or to kind of sanitize states' right to wage war at will. Okay. So we'll be looking at jus in bello. Jus in bello is, how, your right to wage war can actually be curtailed using law. Okay. So that is what a unit 2 will be, the basic, kind of understanding we'll be having. Then unit 3, we look at international and non-international armed conflicts. So the international ones will be conflicts between different states. The non-international ones will be internal conflicts. So we're looking at civil wars and intra-country, not inter-country, inside the country, when wars are being waged, what are the rules and regulations that applies to. Most of the laws that regulate the conduct of warfare is when two different countries are waging war, okay? But when it comes to when the war is being waged within a country, what law actually deals with such a scenario, okay? So when there is a civil war between maybe Nkonya and Alavanyo and all of the other wars, you go to Boko, which is still raging, or I don't know whether it has been solved. What are the rules and regulations that applies to it? The state will tell you that it must use its own local laws to kind of basically regulate the warfare, but there are instances where the state can even be a party to the war, and the state has all the control over the apparatus of the state. And if the state is a party, can't they use their powers and come up with laws that will lead to people not having their rights protected? So we'll be looking at the rules and regulations that governs intra-country or civil wars as they are known. Okay. The main law of armed conflict that we will be focusing on, which I want you to all download, will be the Geneva Conventions. You have about 4 of them. So we have Geneva Convention 1, Convention 2, 3, and 4. That deals with the way wars are supposed to be waged. Okay. Today we'll have a look at the history, how these Geneva Conventions actually came about. Okay. Then we look at when wars are being fought, there's a whole institution of International Committee of the Red Cross. What role do they play in ensuring that lives are saved and we don't engage in unnecessary, kind of atrocities? Okay. And then I think Unit 3 also talks about fundamental principle guiding the Red Cross and all of those things. Unit 4 will come to Ghana and look at some of the institutions in Ghana that are set up to regulate the way conflicts, are resolved. Okay, so in Ghana, you look at our constitution. That is why I want you to download the 1982 constitution. There are bodies, and there are so many of them. So I've just picked some of them for us to discuss. There is the Attorney General and the Ministry of Justice. Attorney General is responsible for all prosecutions in this country. Okay, so when it comes to criminal law, Attorney General is responsible for the prosecution of all criminal offenses. When someone commits what we refer to as a crime, it is not just against the victim, but it's against the state. So the state steps into the shoes of the victim and kind of prosecute the culprit or the accused person to ensure that sanity prevails in the system. The Attorney General doesn't only get himself involved in just criminal matters. When it comes to civil matters, which we will deal with, the Attorney General represents the government. Okay. In Ghana, under our constitution too, he's also a minister, so he's also a politician. Okay. Then we'll look at the Ghana Police Service, how it was set up, what role they play. We'll look at the prison service, what roles they play. We'll link it up with the Geneva Conventions on the protection of prisoners of war and how well we are doing as a prison service. And we'll look at some of the provisions in the convention that tells you how prisoners are supposed to be protected, whether we are actually obeying these conventions. Okay. Then there is the Ghana Armed Forces, the Army, that also it has its role to play. The act that sets it up, we'll look at it. Then I think the last one will be on charge. But when we are discussing the Attorney General, I'll introduce a little bit of the special prosecutor that has been given some of the powers of the Attorney General to prosecute certain offenses. We'll look at it. I think Unit 5 deals with our court structure has so many bottlenecks, and there is this whole concept of alternative dispute resolution mechanisms, where we look at other means of resolving dispute without resort to the main dispute resolution mechanism, which is litigation. So the alternative, we look at negotiation, mediation, arbitration, conciliation, and all of that, different types. So Unit 5 will deal with that. And this one, Unit 5 and 6, you'll be doing your presentation. So with this one, you will be researching into it and providing me with your presentations, so that I'll be examining you on it. Okay. And also the first assessment will be based on the 1, 2, 3 units, which are all based on international law and normally multiple choice questions. Okay. Then the final one, which will also be part of your presentations, will be certain offenses within the Act 30, the Criminal Offences Act. So we're looking at the Criminal Offences Act and the Criminal Procedure. Okay. So Act 29 and Act 30. That will handle it in unit 6. Okay, so we will look at certain salient sections of the Act. So Section 60 of Act 30 tells us about methods of instituting criminal proceedings. Okay, we'll look at category of offenses. We'll look at you normally hear in the news nolli prosequi and all of those things, what it means. Okay, we have things like outre for convict, outre for acquit, all under Act 30 or Act 29 and Act 30. Okay. Then we'll look at Section 96 of Act 30, the granting of bail. It has become a very topical issue, and that will be the last part of our course. So this is kind of a synopsis of what we should be expecting in this course. Any general question before we start today's unit?
Hello, sir.
Yes, sir.
Okay, so my general question has to be with whilst you were taking us through the unit, you made mention of Attorney General being the being a minister, a politician, and also responsible for all prosecutions in the country. I just want to ask that, is it also proper for the Attorney General to be the lawyer for the president?
He's not a lawyer for the president.
No, I am just asking a question.
But he's not a lawyer for the president. Is he?
Yes, what I'm saying is that any issues coming, let's say an issue that affect the president, can the president go for his services?
He's a lawyer for the executive. The president is the head of the executive.
Okay, okay. So sorry, I did not put it right. So being the lawyer for the executives, is it also right?
That's what the Constitution says. So when it comes to right or wrong, we're in a different domain. What sounds right to you might not sound right to me, but should that be the law? Should we change the law? There are debates here and there. Okay. I don't see anything wrong with the Minister of Justice, representing the government of the day. Everything is fine with it. We can decide on whether we will want to separate the Ministry of Justice from the Attorney General, whereby the Attorney General only prosecutes, or we leave the prosecuting part to maybe a special kind of director of public prosecution that does all the prosecution, because the argument that is normally made out there is that because the Minister of Justice is a politician, it's difficult for him to prosecute the members of the executive who are supposed to be his colleagues. Okay. And I think the previous government tried to get around it with a special prosecutor that was giving some of the powers of the Attorney General to do some level of prosecution. But even with that one, there are a whole lot of legal arguments out there. Whether when the special prosecutor is prosecuting, the Attorney General can come in there and use some of his Act 30 kind of powers, such as nolli prosequi and all of those things. So those are the issues. And people also have also advocated that there must be as a separation, kind of a separation, and the political element should be taken out of prosecution. prosecution shouldn't be seen as a political tool. And that is a very current thing that is going on with the Uvuriata and all those other things. But I believe that prosecution is always political, and it must be political. That's how the governance is. Any other question? Okay, let me see if I can project my screen. Just give me a moment. I'm looking for a file and today's on. Sorry. Please, is my screen, is it showing?
Yes, sir.
Yes, sir.
All right. So, legal issues related to conflict management. Okay. And today's lecture is an introduction, and also looking at certain issues with respect to the law relating to conflict management. Okay. So this whole idea of law, I think we dealt with it last year on, when we say law, what do we mean?
Sir, please, some of us are new.
Oh, you are new. Okay.
Yes, sir.
But at least you know about law, don't you?
Small.
Tell me the small you know. What is law? Not just you, anyone can come in. When we say law, what do we mean?
It's a set of rules that govern society.
So there are rules. It governs society. Okay. How does those rules come about, and how does it govern? And how do we even construe that society? How do we get those rules?
Through Act of Parliament.
Through Acts of Parliament. Any other way we can get it?
Some of them we get from the norms of our cultures and
our culture.
Our culture.
It gives us. Can you tell me some law that comes out of our culture? Maybe when you say our culture, you're talking about Ghana, isn't it?
Yes, sir.
So give me a law that comes out of our culture.
Customary laws.
Customary law. So that is a broader thing. So give me one example of a customary law.
I don't know whether the Chieftaincy Act or something.
That act was passed by Parliament, so that would be, it will fall under Acts of Parliament. But our customary laws. Any? Can anyone tell me any customary law?
Yes, sir.
Yes, madam.
Laws.
Yes, sir. So can you say family or land matters?
Yes, there are certain family matters and that are customary. But give me a specific example. What family matter is customary?
Marriage.
Sorry.
So can we say marriage?
Yeah, so marriage, what type of marriage? What marriage? What makes marriage customary? What type of customary law is
Well,
applicable in marriage scenario?
That is the
uh,
customary
um,
marriage.
the ordinance or the customary one, sir.
The customary one. What is so special about the customary one that makes it cultural or customary? Because they marry everywhere.
So can you say the rights and duties of both husband and wife?
Are there any rights and duties of husband and wife? Me, I've not come across it.
That may be related to the dowry we pay.
Now you're being specific. But
The
I'll come
dowry
back to
we
the
pay.
rights and duties of. I'll come back to the rights and duties of husbands and wife. I'm sure she will tell me what they are.
Some of the duties that we pay for to the family soon.
So the dowry is our customary law. Okay, with respect to marriages, and the reason why they are customary is that every location in Ghana or every culture has its way of doing things. In some places, you have to just get some cola and some small pot of pito or something, and that's fine. In some places, you have to buy a whole head of cattle. In some places, you have to bring a bottle of apetition. So it depends on the culture of the people and what they demand as the bride price. In some places, you have to go with a sack load of clothing. So every area and its custom that is applicable to marriages in that area. Okay, that is an example of customary law I'm looking out for. Also, one general thing that runs through our customary marriage is that the men can marry as many women as they want. But the reverse is not true. That's one custom. Whether it's fair or not, I think we can have a debate on it some other time. One other customary law is that it depends on where you come from in Ghana. If you come from a place, maybe in the northern part, some place of Greater Accra, some places in Volta region, they have what we call the patrilineal system of inheritance. You belong to your father's family. That is the custom of those people. If you are an Akantu, they have the matrilineal. You belong to your mother's family. So you inherit from your mother's family. It applies to even our land laws and all of those things. If you are not a member of that family, you cannot have access to the land of that family because you are a stranger to the other family. These are the customs in Ghana that are also parts of our law. Okay, which we will deal with when we come to looking at the Ghanaian part of our course. Okay, so in general, I like what you think, what you said, that laws are rules, and the rules, I think you said Parliament will pass some, and also the custom will also come through. In Ghana, the biggest law we have is the Constitution, which is the supreme law of the land. Any other law that is inconsistent with the Constitution can be declared by the Supreme Court to be void. Okay. So all of those things, we will look at them separately. Okay. But what happens when there is an issue between Ghana and the Republic of Togo? Which law will be used in deciding? You remember some time back, Ghana had an issue with Ivory Coast on our maritime boundary. Which country's law should be used? Which country's rules and regulations should be used? So the first part of this, our course will be to look at the laws that are applicable to nation states in their dealings with each other. What law governs those things? When countries are at war, when Donald Trump says that he believes that Christians in Nigeria are being persecuted and he wants to intervene, what law should guide his intervention? When Ukraine and Russia is said the Donbas part of Ukraine is part of Russia, what kind of law should deal with that? When
Sir, please,
Yes.
So, sir, the law you are talking about, is it the same as the public international law?
Yes.
All right, sir.
What do you know about the public international law?
I heard it, but I've not read about it, sir.
You heard about it. So that's what we'll be looking at today. Public, whether there's anything like a public international law. And in Ghana, we have our constitution. If someone does something to you that is unconstitutional, what do?
You go to court.
You go to court. You go to the police station. You go to Shraj. You go to other places. If we should take that to the international realm, where do you go to when that international law is being breached? If let's say you are a citizen of let's say Ukraine, Kiev, and the bomb is coming, the bomb destroys your property, who do you report Russia to?
International.
Maybe the IT.
Sorry.
Is it international court?
Yeah, international court. And the international court, how are their laws enforced? Do we have international policemen?
Say come again.
I said, are there international policemen that will enforce the international court's law? Okay. So let me.
I think we have Interpol, so maybe they
Yeah, I
might.
know. Yes, I know. So we look at Interpol. They haven't been able to bring Oforiatta. Anyway, so this was just to get your head around what we are going to be looking at. It's not very clear cut, and it is difficult, but necessary. It will take you a little bit out of your comfort zone. If I'm saying anything that you don't really get it, stop me and let me try and explain a little bit. It will involve a little bit of reading further in there, because this will not be something that you've been used to. Okay. So the idea of law, the slide talks about, predates the existence of humans. Even before human beings were created, if you look at the biblical, if you're a religious person, there was some law before even human beings came in. There were certain rules and regulations. You know, God created night and day, and there was some order in the universe before he created, human beings. And the way in which individuals settle this, and when human beings too are there, and because human beings are different individually, there is bound to be kind of disagreements between us. Okay. And the way in which disagreements can be settled is being influenced by law. Law is what we use in settling our disagreements. The disagreement could be over the use of resources, could be so many: telecommunication disagreement, environmental disagreement, family disagreement, criminal disagreement. So law is the way that human beings, civilized as we are, use in settling our issues or our disputes. And it applies to everything from interpersonal interactions, settings. It goes all the way to groups. When different groups have different issues with other groups, they use laws in settling those problems. Norms that govern how members of a society should behave towards one another. Okay. And they form the foundation of any morally just society. So in any proper society, there must be rules and regulations that governs the way we are supposed to interact. Okay. Law is very, very essential, because every disagreement contains an element of morality. Okay, if we disagree on something, it could be because of your perspective. I was asked the question whether maybe it is right that the Attorney General should be the lawyer for the president, and I made a slight comment that because what may be right to me will not be right to you, okay. But the state comes together and puts down certain laws and say these are our rules and regulations, these are our norms, okay, and there are ways through which those laws are actually kind of given to us. When I asked what kind of laws we have in this country, someone said acts of parliament. Okay, how do we have the members of parliament? We are all supposed to be involved in the election of our members of parliament. So we've given them that moral avant-garde who are the conscience of our nation that will make rules and regulations that governs the way we do things. Okay, so disagreements contain elements of morality and they must be settled by the application of principles that are considered morally acceptable. If someone is doing something to another person and you feel in your gut instinct that that is not right, there must be rules and regulations, or there must be laws that can actually be used to kind of right that wrong that is being perpetrated. Okay. So we look at McFarland 1999, page 43, expatiates on some of these principles. Okay. If you go way back, there are what we call jurisprudence. Jurisprudence is what we refer to as the philosophy of law. What is the main reasoning behind why we must have laws to govern societies that we live in? Okay. We have different philosophers or different theories and their way of looking at the reasons why we must have law. They can be broadly kind of divided into three. We have the positive law, the natural law, and the realist law or the realism. Okay. Natural law, we have theorists such as Thomas Aquinas, who says law is nothing more than the ordinance of reason. He says law is anything that is reasonable to you. Okay. So there are sayings such as all immoral laws must be disobeyed. Okay. If the law doesn't make sense to you, then it is not something that you must allow to prevail. Human beings have that innate common good in them or common sense in them that tells them that this thing shouldn't be allowed. It tells you that if someone spends his energy to grow his plantain and you, when the plantain is ripe, go and cut it off, it is not nice, it is not good. So there must be laws to punish it. We call it theft. When you appropriate someone's property and your main intention is to deprive him of the use of that property without that person's consent, because it is not good, it is not fair. It is something that any rational person will let you know that it shouldn't be allowed to exist in a proper society. So those people are what we refer to as natural law theorists, that law is nothing other than an ordinance of reason for the advancement of the common good, made by him who has the care of the society and disseminated. Some of these natural law theorists believe that it's God that gave us that right to have certain rules and regulations, and they can trace it all the way back to the 10 Commandments and all of those things. You love your neighbor as yourself. You will not hurt your neighbor. If you are supposed to care for that neighbor. So the natural law are things. The natural law theorists believe that law goes with common sense. Okay, it is something that everyone, it is innate in us. We are all supposed to be moral human beings, and things that are not right, we can see it. You don't even need, when you enter a country, okay, you don't have to go and read their constitution to know that certain things must not be allowed to operate in that country. Okay, you don't need to be a legal scholar to know that a child should not be abused. You don't need to be a legal scholar to know that basically certain things must be construed as an offense. Okay, so the natural law people they believe that these are things that, being as human beings, we believe must not be allowed to exist, and we set up laws to protect us. There are other people too who believe that
when you base everything on natural law, what looks like right to you might not be, something that looks to me to be right. If very much you open the floor and ask the question, should homosexuality be permitted or should it be made a criminal offense? I'm sure there will be different opinions. Yeah, I'm sure the majority will say, no, it's against our culture, I'm sure a few too will be humming under their breath. But what someone does in his own bedroom, has it got anything to do with the state? So it is not always that you leave things up to people's own moral whims and caprices. Okay. There are certain times that we believe that the law should be what has been written down, or what not only written down, what has been stated to be the law. The positivists, they believe that the law is what it has been posited down, something that has been written down, or something that has been stated. Okay. So the conception of law held by positivists is built on the concept that it is the possession of the rules that are generally acknowledged, along with the authority to carry those rules out. They believe that if Parliament says engaging in such a thing is unlawful, there's no point going back to say, as for me, it is not nice to me, it is immoral, it doesn't make sense to me. If you do that, you make the law a very subjective thing. So positivists think that the moment the law is written down that this is the law, that is what must be applicable. So if you want any law, if you want anything to be law, state it. Tell the people. Let them know this is the position of the law. And they are the positivists. And for them, if Parliament passes a law, it is not up to me to go and say this law, Parliament passed it, but it wasn't good enough, so I'm not going to obey it. Remember, there was a time that Parliament passed an LI that allowed for the mining of gold in forest reserve. That was the law. People were mining in the forest reserve, but people thought that despite the fact that Parliament has passed that law, mining in forest reserve is something that endangers the environment. Until the Attorney General went to withdraw that LI from Parliament, those people who were mining because they were mining the law. That was the law at that time. You can argue, to destroy the environment and all of those things, but that was the law. So positivists, they look at the position of the law, and those laws, it must be stated in such a way that it is something that is there. It tells you this is the law. If you go against it, these are the sanctions. And the sanctions are just going to be operationalized by the law enforcement agencies in the country. Then we have different schools of thought that we cannot go through all of it because it's not a jurisprudence class. We have the realism. Realism, they believe that the law is in the bosom of the judge. They believe that the law is what the judges say they are. Okay, because sometimes you go to court, you make all these arguments, and the judge says, "I'm not impressed," and it's the judge who makes the pronouncement. So whether they interpret the Constitution. Some of them, we call them, they use the literal interpretation of the law. Okay, some to use the purposive interpretation. Literal interpretation is where you look at the black and white letter of the law. Okay, so we had a scenario in Ghana where the Constitution, the black and letter law, says that after we have finished the election of a president, the person who presides over the election of the president, he shall sign the return of the poll sheet, the pink sheet. And basically, that was the law. The presiding officer shall sign the pink sheet. So after 2012 election, there were certain pink sheets that were not signed. Okay. So someone who is a positivist will sit down and say, if the law says you should sign and you don't sign, then that election, it must be cancelled. Okay? Because that is what the Constitution is saying. You shall sign. And shall is mandatory. Then some who are natural law went in there and say, but is it fair for us all to go and queue and vote and go home? And some guy who is not even an employee of the Electoral Commission but has been given a part-time job by the Electoral Commission decides not to sign. Isn't he disenfranchising all the people who went to vote at that election? So the judges sat down and they came up with a decision that it is not always that we should follow the positive aspect of the law that's saying presiding officer shall not sign, so that if he doesn't sign, it invalidates the whole kind of election, that was carried out. The fact that the person didn't sign, maybe it was an oversight. Maybe the person is not even properly trained. Why should they lead to the annulment of the results? In this area, we can argue that the law, instead of it being the black and white that is written in the Constitution, has now been given to the judge, who will determine that when something is written down as shall, the judge, will make it a may. Am I clear? So that area of law we will say is realism. The law actually is in the bosom of the judge, and the judge is the one who interprets, and he might decide what shall is shall or shall can be made. Any questions so far? Yes.
Please, the law is in the bosom. I can't comprehend that because if that is, there will not be a need for president, because some they do reflect a certain previous judgment and then pass judgment current happening. So if the law is actually within the bosom of the judge, then he can ignore the president and then pass whatever.
Yeah, that's true. If there's a president and the judge can decide, depends on the type of court you are looking at, then the judge might be bound. But if there are no presidents and the court is the highest court of the land, then they can decide to come up with what they feel is right. You get me?
All right, sir.
Any other question on this? So these are philosophies and jurisprudence that you can do some more research on it. Okay. Any other question? Can I move on?
Yes, sir. Let's proceed, sir.
All right. So that is the general backdrop. That is the general backdrop of the philosophical underpinnings of it. But as I told you, today we are going to focus on what I refer to as states, in their interactions with each other, the law that actually applies, and it's called the public international law. Okay. We now refer to as PIL. But there are two types of PILs anyway that we'll be going through. But the other one, I'll use the full name, and this one, public international law, I'll refer to it as PIL. Okay. It says is that body of law which is composed for its greater part the principles and rules of conduct which states. So here when we talk about states, independent states, okay. And in some, instances, not just states, but international organizations, they feel themselves bound to observe, therefore do commonly observe in their relations with each other. So what we're looking at today is when there is a conflict between two different entities or two different states, what law should be applied? In Ghana, you can go to our Supreme Court, you can go to our courts. I'm sure Nigeria too, they have their own court system. You can go to our parliament, you can use our charge, our special prosecutor to resolve conflicts within the municipality, within the country. But where the conflict is between states or between state entities or between international kind of groupings, what law must be applied? And in the olden days, if you look, I'm sure some of you used to watch Roman movies and all of those things where you see people on horsebacks and the rest. Whenever any state wanted to, there was a conflict between two different, kind of groupings, all they had to do was assemble a huge army, mass up, go to war. So every country had a huge wall that must be fortified with an army whereby they will protect the walls of that country against any external aggression. But within that country, they have their own rules and the way they run their things. They have their own laws. But when it comes to dealing with the external kind of a different country, there were no kind of public international law that dealt with those things. So all that states had to resort to was, if there's any disagreement, you just fight. But public international law has been developed with time to regulate the activities that states, will, that have conflict with each other, how those things are supposed to be basically resolved. And it is a law that keeps on evolving. There was, in recent times, public international law is facing a whole lot of challenges. I was even thinking maybe I'll give to my law students an assignment that public international law is dead, discuss. Maybe I might think about it and give it to you guys, depending on how nice you are. So you look at a country like Venezuela, okay? They hold an election, someone is supposed to have lost or to have won and blah, 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 And America decides that the person who is in power, they don't like him. So they send troops over there, capture Maduro, and now he's in America facing the U.S. courts for one of the charges was that he was in possession of a machine gun. If a president of a country cannot possess a machine gun, then who else can possess a machine gun? Okay. So when he was possessing that machine gun, was he possessing it in New York, or was he possessing it in his country, Venezuela? And when you charge someone with possession of machine gun, the place that he possesses it, shouldn't he be part of the law? And a country can't, a president possesses a machine gun. So what law allows for another country to enter another country and take that country's president and go and kind of dump him in another in that country's prison? Is there anything like a law that regulates the activities of nation states? As I have already said, just recently, there was this threat of taking Greenland by force, but now it has calmed down. Before then, there was the Israeli-Palestinian kind of issue, whereby the Palestinians decided to go to Israel and go and just kill people. And the Israelis also retaliated. So is there any law that regulates the activities of nation states in their interactions with each other? If there is such a law, then the name for it is public international law. Any question?
Sir.
Yes.
Please, I want to ask you a question.
Feel free.
Yeah. I want to know to what extent can public international law be enforced without a world government?
So we'll get to how public international laws are kind of enforced. And they're enforced by the signing of international treaties, international conventions, and there are rules and regulations that deals with it. Okay, there are international bodies that are supposed to observe that. We'll go all the way and get to the United Nations and the Charter of the United Nations that tells you about how public international laws are supposed to be enforced. We'll get to a place whereby there's a body called the Security Council that is supposed to be the avant-garde, the world police officer that is supposed to ensure that international rules are observed. But there's a whole lot of politics. There are institutions or there are countries in there who are called the permanent members who have the veto powers, and it has kind of crippled the United Nations from doing its jobs. We'll get to all of those places. Any other questions?
Yes, sir. Yes, so in the case of Nicolas Maduro, it looked like the other reason was drug trafficking.
That's right.
So we juxtapose that with international laws and all of that to see whether even US had the right to capture because of that.
Yeah, so the drug trafficking was there, but where was he trafficking from? Where to where? Where was the jurisdiction? Okay, if someone is somewhere and you're saying he's trafficking, drugs to your country, where was he trafficking it from to where? Okay, so these are issues. These are issues, and to bypass the country's laws and just go and impose your law on them, it kind of feels that the world order is actually changing. Okay, if today basically Nigeria comes up with some charges against the president of Ghana that they believe that the president of Ghana is running some Sakawa or some 419 Yahoo kind of thing from the Jubilee House and comes to capture the president, would that be international law? Okay, and if you can legally go to someone's country and capture him, then why are we worrying ourselves with Oforiata, Interpol, Red Alert, and all of those things? Couldn't that have been used? Anyway, these are issues that we can deal with later on. Okay. So international law is a body of rules which are legally binding on states in their, I think the word intercourse is a bit strong, in their interaction with each other. Okay. They primarily, those which govern the relations of states. Okay. So public international law is the rules that govern states in their interaction with each other. Okay. And it could be, how disputes over land, dispute over water bodies, dispute over so many things, how even the countries are supposed to observe human rights principles and all of those things. These are public international law. And it is normally done in the form of international treaties and international conventions that countries must expressly go out there and sign up to them. Because what nation states normally do is that they believe in the principle of state sovereignty, that whatever happens within the boundaries of my country is an internal matter and it has nothing to do with any international body or any international organization. So a state must expressly go out there, sign international conventions, international treaties, agreements with other states before public international law can be effectuated. These rules are those which govern relations between states, but they are not only, the subjects of international law. International law can also be applicable to international organizations, okay? And to some extent, also individuals will be subject to rights conferred and duties imposed by international kind of law. So it's not always states in their dealings with each other, but also international organizations are also subject to international kind of law. We have all these UN bodies and the rest, and they operate under international law. They have certain kind of immunities and all of those things. Nation states also use embassies and diplomacy to kind of flesh out their international law regime. Okay. Also, apart from having public international law, there is what we call private international law. Okay. So the public one is when nation states are dealing with each other, where they sign conventions and agreements and treaties. Okay, so we have agreements such as the ECOWAS treaty, the AU treaty, we have the UN Charter, we have so many Convention on the Rights of the Child, human rights charters, and all of those. These are all rules and regulations, and these are all states that have come together and decided that this is how we are going to, govern ourselves in our interaction with each other. We have signed international agreements, and that is what must be applicable to us. That is when nation states are dealing with each other. We have the other aspect to where private individuals, we have what we call private international law. So the international law has got two elements, public international law and private international law. The public element deals with nation states and international organizations, but private international law governs individuals, entities, companies and the rest, and there's a private international law.
It is private because states are not normally involved, but that doesn't mean states cannot be subject to private international law. So international law is what happens normally when maybe you are in your home, you've gone on maybe Alibaba, you've ordered for some things to be delivered. The things are going to be shipped from China, or you want to import some car from the United States of America. You are in Ghana, you are the buyer. The seller is actually in the US. Private international law is the law that will be used when the thing arrives and there are certain defects. Private international law is maybe you are an Ivorian, okay? You've met a Togolese in Kumasi, and you have married, okay? Maybe at the registry in Kumasi, and both of you have decided to go and live in Sierra Leone, okay? When you decide to divorce, which country's law must be used in settling your properties or in looking at the divorce? Is it going to be the law where the husband comes from? Is it going to be the law where the wife comes from? Is it going to be the law where they married? Or is it going to be the law where they are living at the time of divorce? So you can see there are so many different laws that can be applicable to that marriage. Private international law deals with what we call conflict of laws. Maybe in Ghana, you have to have a reason for divorce. Maybe in Togo, you don't have to have a reason. So there are different countries, and private international law looks at these different treaties. Our focus will not be on private international law. That will be for law students. But for us, our focus is going to be on public international law. But I just wanted to bring in that distinction that there's also private international law that deals with individuals, entities in their interactions. So, private international law can even involve the government. The government of Ghana is in so many arbitration kind of issues with international organizations, okay, whereby maybe you go and sign an energy contract with maybe Ameri or some other international organization, and that organization is coming from a different country. Ghana is a different country. Then they will state in there that whenever there's a dispute, we must send it to an arbitration center in London, and the laws that must be applicable should be maybe English laws on contract and what have you. These are all private international law matters. Okay. Please, the distinction between public international law and private international law, is it a bit clear?
Yes, sir.
Okay.
So,
Is that the same for everyone?
Yeah.
Say it again, sir.
So please, can you throw more light on it, sir?
Where should the light head?
The private international law, sir.
So, okay, then let me start from the public is when governments are dealing with each other. Is that okay? So when nation states are dealing with each other, it's public international law, isn't it? The private international law is where individuals or entities that are located in different countries and they have issues that cover so many other places. If, let's say, you are in Ghana, you've gone to buy something from KJTR, and you come home, and the thing is not, it doesn't comply with what you thought you were buying. Okay, the law that you use is maybe the Sale of Goods Act in Ghana, because it's a Ghanaian thing. KJTR, is the Ghana law that will be applicable. If you think the person is even being a fraudulent person, you can report to the Ghana police, and that's it. Okay. What if you didn't go to KJTR, but rather imported it online from, let's say, Venezuela or from US, and the thing comes and it's not what you want? Which law must be applicable? Is it the United States law or Ghana law? Which of them should be applicable? In this instance, we refer to private international law because it is private individuals in their own commercial dealings where there has been a conflict. So there are rules and regulations that governs the way private international law actually goes in there. Private international law, and I gave you the point of marriage, distribution of marital assets and all of those things. Private international law will let us know where the people are habitually resident. That is the law that will be applicable. These are all private international law matters. And I stated that we will not focus too much on private international law, but we will deal with the public aspect of it. But just to let you know, there is a there's the private element of international law. That doesn't involve just between states in their interactions with each other. Is that okay?
Yes, sir.
Yes, sir. Solid.
So the composition of public international law, okay, it regulates relations between sovereign states and international organizations. I think I've stated this, okay, and as well as transactions between both legal and non-legal parties, okay. So when I say legal and non-legal, an entity such as ISIS, is it a legal entity? Is really a non-legal entity because it doesn't really have any proper, it's a banned entity and the rest. But public international law deals with such people. It deals with insurgents, you know, people who are not operating. So you look at Boko Haram, they are in between Nigeria, they are in between Niger, operating fringes of states and all of those people. Those entities, public international law can be applied to them, okay. We have the Lord's Resistance Army between Rwanda, Congo, and the rest. We have that one is in Uganda. We have there's a new one, MLA. Okay. There are certain organizations that straddles along different kind of countries. Okay. These are rebel groups and the rest. Public international law deals with them. Okay. So the subjects of public international law, that is the persons and entities to which the legal order grants rights and on which it imposes duties. For example, public international law applies to states, international organizations, and as I stated just now, insurgents and so on. Those are the subjects of public international law. But in certain instances, too, individuals can be subjects of public international law. So if, basically you're an individual and you have been tortured by your state, you can invoke public international law that is against your human rights, that certain things are being done to you, and take your matter up in international courts, and they can actually give you reliefs that you are seeking. So it's not only kind of countries that public international law applies to. Public international law can come all the way down to protect individual rights in certain, kind of limited circumstances. That is when the local law, the municipal law has not been able to provide adequate remedies towards breaches of, the rights of certain people. So the subjects could be countries, it could be international organizations, and it also could be, insurgents and even individuals. Okay. So there's a relationship between, when I say municipal, what I mean is internal or local and international law. Okay. So when we say in Ghana, our municipal laws, we're talking about the laws that are applicable in Ghana here. Our constitution, our acts of parliament, our legislative instruments, constitutional instruments, and etc. Our common law and what have you. Those are the laws that operate within the entity called Ghana. Then there's international law, that is through the signing of international treaties and what have you. We have seen that all of the states possess an internal legal order. In Ghana, whenever there's a problem, the internal order will operate. We stated here the Attorney General is in charge of all prosecutions. So if there's a criminal case, the Attorney General will be in charge of it. Okay. But when it comes to international law, the state's internal organs are not adequate, because as a police officer in Ghana, you can't just wake up tomorrow and say, I'm going to Nigeria to go and arrest someone there because I was chasing the president and he's run away to Nigeria. Nigerian law will be applicable. Okay. So local laws, internal order, we have the internal organizations that deals with it, and we'll look at it in the second part of our lecture, whereby we'll look at the police service of Ghana, the prisons, the army, and the rest. Okay. But when it comes to international law, it stays in their dealings with each other, and they have to obey public international law rules. The relationship between these two legal orders, that is the local law and international law, it must be clearly defined. In places or in where local law contradicts international law, which of them must prevail? If a local law is saying this is what must happen, okay? So basically, if you look at certain international kind of human rights conventions, there are certain, kind of human rights that are allowed in other places and that, Ghana has been subject to. We also have our own kind of cultural values and what have you. Where there's a conflict between that international obligation and a local law, which one must take precedence? These are some of the issues that we'll be looking at. And also, one element of public international law is that no matter what the case is, disputes must be settled in a very peaceful manner. Okay. In every relationship between human beings or entities, there will be some form of disputes or differences of opinion, and they may need to be solved. If it is an opinion within the borders of a country, then the local law will be applicable. But when it is between countries, then there must be friendly international relations between each other for us to solve it in a peaceful way. Public international law is the peaceful, it regulates peaceful settlement of settlement of international disputes, so that we don't resort to war. Okay. So these are some of the basic tenets of public international law. Okay. The composition. So I stated that the subjects of the law are states, international organizations, insurgents, even sometimes individuals. I've stated that there's a relationship between local or municipal laws and international law. When they conflict, what must prevail? It depends. Okay. Because if every state says my internal law must take precedence, then there will be no international law. So sometimes you give way to the international law to prevail. Okay. Then I've also stated that the main essence of international law is the peaceful settlement of disputes. So at any given time, when nation states are dealing with each other, they strive to achieve peaceful means of settling those disputes without resort to war. Okay. One element of public international law is what we refer to as the law of armed conflict. But before we start with the law of armed conflict, any question on the components of public international law? When I'm presenting on my computer, I don't really get to see your name, so I'm not able to call you and ask you questions. Maybe I should stop and start asking questions, because I'm sure some of you have put a phone somewhere and you've gone off. Is there any question on public international law? I know it sounds different, is maybe different, and some of you didn't even look at you are not part of us when we were looking at law and society, so these are kind of new things. But you only get to understand it when you ask questions. So is there any question on public international law? Hello, am I still online?
Yeah.
Yes, you are here, sir, when we are with you, sir.
Then you are offline.
Yes, sir.
You are offline to me, because I'm not getting any questions.
Then we are live, sir.
Okay, you are live. So Lambon,
I want to ask.
your hand is up.
Yes, sir. I want to ask a question concerning this Lumba and then the wife issue.
Oh, Lumba.
Yes, sir.
Okay.
Wouldn't they have used this public relation?
Private international law.
Yes.
They could have. Which of the teams do you belong to?
I belong to Team Legal Wife.
Okay. So hello, am I online?
Yes,
Yes,
sir,
sir.
you are live.
Yes, sir.
Okay. Okay, okay.
Master, you're
So
online,
yes,
Papa,
so
Papa.
the question is, couldn't they have used a private international law in determining those things? I think what happened there was who must
Yes,
be allowed.
I'm having some online lectures.
Sorry, you know.
Oh, please, kindly mute your microphone.
Are you coming here?
Yeah, I think that's fine.
Enoch, your microphone is on and you are disturbing the class, so kindly check that for us. Enoch.
I think I've muted him. Isn't I've done that, so don't worry. It happens. So whether the Lumba issue was an international law matter or it was an internal law matter. Okay. My take was it was an internal law matter. Because if I have it right, it was to decide who has the right to perform widowhood rights, isn't it?
Yes,
So
sir.
that was a purely customary law matter. That in Ashanti custom, who is the one who's allowed to perform the widowhood rights? Wasn't that the issue?
Yes, sir.
I think the only international element that came in was whether they were determining whether the other one was a legal wife or wasn't a legal wife, isn't it?
Yes,
That was the only. Yes.
Please, this PIL in the model, is it a private international law or public international law?
It's a public one. It's a
Public
one.
international.
So remember, I told you when I say PIL is the public one. The private one, I normally mention the full one, and we are not even concerned with that one.
Yes, sir. Yes, sir.
So basically, I think the Lumba issue was a local issue. It's just that he married one of the wives in Germany, but when the judge was looking at whether the woman was properly married, she went a little bit into private international law, where she says the marriage certificate that they brought wasn't, the proper one that she wanted. I think she wanted it to be interpreted, and she didn't want the extracts from the marriage book. So at that time, maybe if they had been able to bring some experts or someone who knows about German law to come in to explain, maybe it would have swayed the judge in deciding whether legal wife was the proper legal wife. But we say it's team legal wife, but when the court sat down, they didn't see her to be legal wife. Anyway, any other question?
But sir,
Yes,
on
sir.
that
Oh, sorry, let her finish, please. Then you come in.
yes, because according to the information we gathered, he was denounced as a Ghanaian citizen.
Who?
Lumba.
Lumba wasn't Ghanaian.
Yes, he was a German citizen.
What?
He was according to a German.
Yeah. Okay. I don't know. I don't know about that.
And so couldn't they have sent the matter back to Germany to kind of?
No, it was about who should who should go and perform widowhood rights. I don't think in Germany they perform widowhood rights.
Oh, okay.
So it was a customary law matter.
Okay.
So how many wives? So in Ghana here, you can have the two wives. I don't even know why they even went to court. The two of them can sit down and perform it.
Okay.
So the judge wasn't looking at whether Lumba was a German national or was a Ghanaian national. And it was about the customary law. What's the name of the bishop in Tupac? And the Tupac guy, he's from Lumba's mother's side, isn't it?
Yes.
But under Akan custom, when you die, it's not your mother's side that bury you, it's your father's side. So I don't even know why he was making noise. Anyway, I don't know the details of it. I'm sure you know much on these things, but it's important. But there was an international law element to it in some way.
Okay.
Any other question? Yes, Sir Francis, I think you wanted to say something.
Yes, sir. I wanted to say that before I come to my question, she was saying so German accept dual citizenship, and then Ghana also accept. So Luba can be a citizen of Ghana at the same time.
Germans, I'm not too sure. Do they have dual citizens?
Yes, they accept. They've
it.
accepted. Yes, it's recent.
It's recent because I remember
Yes.
back in a previous life, I used to work in UK, and they never used to Germany, Holland, and the rest.
Yes,
when you
they-
get their when you get their passport, you have to throw away your Ghanaian passport.
Yes.
Yes, they've finally
They've changed
do
it. Oh, okay.
Yes.
Okay. That's fine. So now
So,
let's come to the
hello, sir.
Yes.
Can I ask my question now?
Okay, go ahead.
Elements of a domicile,
So
whatever they call
concerning
it, per where the man, some time ago he was in Germany, and now he has been in Ghana, where his original domicile was, and he's been here for about 15, 17 years plus, and everything that he has done tilts towards the fact that he has come back to his original domicile, and therefore that one negates the second one he went for. It's another leg of argument that I heard. I don't know how it works.
There's a lot of rumors around, so let's deal with our stuff today. So I really must confess I haven't really gone into the detail. I haven't even read the I know that the judge who delivered the first judgment, Dorinda, I've appeared before her several times. She was in Cape Coast, and she's been moved to Kumasi. And the second one, Justice forgotten his name. He was also in Cape Coast. I appeared before him several times. He's the one who granted the injunction and told them to go and bring 2 million there and then. So, but it's an interesting case. Let's see what happens. But I think Sir Francis wanted to ask a different question.
Yes. My question is, there is a recent this thing concerning Tada, and then the people he lended money from them to do his.
Who's that?
Tada.
Who's
Tada.
that?
Tada
So
or
that
Tada?
Cheddar.
The name is
Nana
Cheddar.
Kwame
Yeah.
Bediako, the previous presidential aspirants. Even before election.
He lent money to someone.
No, he wanted, like, it was initially it was a joint thing that they were doing, and then later he used, according to the news, he used their company to borrow money from other shells. That is
The name is
something
Cheddar.
$1 billion. And then yes, Cheddar. So now that the UK, the case is at the UK court, and then Ghana, I think Supreme Court also visited the same case, and now he is saying that the co-partner who is involved is the white man is doing galamsey in Ghana here. So in that case, is it going to be a private, or it is it is going to be the like, is it international, or it's going to be national? Because it's also raising up a different thing, and I'm a bit confused here.
And honestly, I've not heard of that issue. But so Cheddar is in some transaction.
Yes.
And between, he had a business with with a foreigner, isn't it?
Yes, foreigner.
And there's a dispute.
Yes.
And the case is in UK court, isn't it?
Yes. And the Supreme Court also.
Okay. They have decided the case also in Ghana.
Yes.
Oh, okay.
And now that he's proving that the one involved is also doing galamsey in Ghana, and now Ghana to galamsey issue is now something else.
But I think that will be. But I don't think their dispute is on galamsey. It's on something else, isn't it?
Yes, the dispute is not on galamsey. It's on the money matter. He built something at. He built a house at the estate that he built at the Atomic road. No.
Okay.
He built some estate there, so he lent the money from there.
So basically,
through
it's
the
a
money that
contract.
he
Maybe he's lent some
yes,
money and
yes, it's
stuff
a
like that.
contract. Then
Uh-huh.
his petroleum city that is building at Takrady too. He uses
Okay.
that joint thing to borrow money from different source again.
Okay.
And then so since that
Yeah.
they are
So here, private international law is applicable because he's straddling different jurisdictions. There are some issues, some international contract issues in London or in UK, and there's some elements in Ghana here. So private international law is at stake. So we'll look at, the UK element of it. UK law will be applicable, the Ghanaian law, and I'm sure the agreement they will state in the agreement which is the applicable law they want to use. So that is where private international law comes into play. But I don't really know the details of what happened in that case. And if let's say normal thing that normally happens sometimes is maybe there could be a case against someone like an international person like Sheda or any other person. And then maybe the UK court will say that they have awarded certain damages for maybe let's say the business partner who's in UK. Okay. The only thing that will be left will be the enforcement of that judgment given by the UK court. There's a treaty that governs the enforcement of international awards. Okay. Ghana is a signatory to that award, that international convention. UK too is a signatory. So they can come register the award in Ghana or the judgment in Ghana here, and it can be enforced just like if the person had gone to the high courts in Ghana here. So it's allowed. Maybe you are chasing someone for money and the person is in Ghana, his assets are in Ghana, but the contract was performed, the laws of UK was governed. So long as the UK government have come up with a decision that you owe this person this amount of money, and they know that you are you having certain properties or assets in Ghana, they can use that kind of international convention that both countries are signatories to come and enforce it, come and sell your house in Ghana to go and pay for your debt in the UK. Private international law deals with that.
okay. So but this Geneva Convention, I don't know if I'm mentioning the right word.
Oh, we haven't gotten the Geneva laws. Those ones, they don't deal with private individuals in their interactions with each other. Geneva laws, we'll get to it. That is what we are moving to. That's our next part of the lecture.
Okay.
Any other question?
So, sir, on the same matter about charter issue that my brother raised, I just want to find out that won't there be any bias? For example, I enter into a transaction with let's say a UK citizen, and there was a dispute, and the matter is being settled at the UK courts. Won't there be any biases towards the other partner, considering the fact that the person is a citizen or in a said country?
Yeah. Okay. Yes. So basically, when it comes to such international contracts, they have what we call arbitral clauses, and it can even be between a company and a state. If let's say the Ghana government is going to sign maybe a power purchase agreement with an international company, the international company might decide that should there be any issue, I don't want Ghana law to be applicable. So they will put in what we call an arbitral clause, whereby they say whenever there's a dispute, let's all go to a neutral forum, maybe UK, and go and arbitrate it. Don't let us use the Ghanaian law because there'll be bias. Okay. So that is how you cure that mistake. So if you're signing and maybe a Chinese company is entering into an agreement with a Ghanaian company, they will state which law must be applicable, which law governs this contract. Because if you make it China law, they believe that the Chinese will favor their citizens. If you make it Ghana law, they believe the Ghanaian courts will favor the Ghanaians. So what they do is they give a neutral country's law, and whenever there's a dispute, you take it there for that issue to be resolved. And that is private international law.
Thank you, sir.
All right, let's continue. We have some more time.
Please, is my slide showing?
Yes, sir.
Yes, please.
Okay, so when we say PIL, Public International Law, there's a branch of it called the Law of Armed Conflict. The law or International Law of Armed Conflict. So LOAC is a branch of public international law that when conflict happens, whenever states are in disagreement, they try and solve their issues using diplomatic or peaceful means of settlement of disputes. Okay, but there are instances where diplomatic means are not enough, where things break out into armed conflict, where there is war. Okay, so the law of armed conflict comes in to regulate the way in which wars are waged. Okay. At first, as I told you, whenever a state had certain interest and it believes that another state can help it fulfill its interest, it goes in there and take or make use of whatever it can get. So if you go way back into history, we have in 14 something, we had the Portuguese coming to our shores in Elmina, coming to build castles here, taking some of our people into slavery, and it went on for hundreds and hundreds. It went on from 14th, from 15th century all the way to the 19th century when slavery stopped, because the Europeans needed labor to work on the discovered lands in the Americas. They were using just kind of brute force to get people from this part of the world to go and work on plantations for them. Then it changed into colonialism. Okay, in Ghana, ours started with the Bond of 1844, where certain fancy chiefs came together and stated they wanted the application of English or the British legal system in governing disputes here. The British took advantage of it, started setting up their branches of government and the rest, and it turned into a colonial system, whereby they exploited our natural resources to their advantages. And some will even argue we're still under colonialism because our economy is still geared towards the production of resources to satisfy the needs of Europe. Okay. So states have used armed conflict to satisfy their national interests. Okay. But all these things went on and on and on, and war as a means of settling dispute has its grievous disadvantages. Okay, so this part of the course will go through how come we've now been able to get certain laws that regulate states when they are engaged in armed conflicts. Okay, the best way that states can use in resolving their disputes is to set up diplomatic channels, embassies, and the rest, and sign treaties, conventions, and the rest to solve their problems. But where that cannot be done and state resort to war, there must be some law that governs the way such wars are actually waged. So when there's conflict between states in their interactions, whenever states are protecting their sovereignty or their territorial integrity, there must be laws that actually stops them from being aggressive towards each other. So states continue to utilize force in their interactions with other parties. And any regulation of this use of force, whether legal or illegal, legitimate or illegitimate, is necessary. The law of armed conflict comprises of rules that governs the sort of weapons, the tactics that you use, and how we have, people that we term as protected persons must be protected. Okay, so that is what the law of armed conflict is all about. It's about, wars must not be encouraged, but because human beings have, sometimes can decide that you can use war to resolve your dispute, your conflict, the law of armed conflict has come in for us to regulate the way wars are fought. And that's why I told you in the introductory lecture that there are philosophers, Carlos von Clausewitz, who say that, the thing is, we are at war. Why should there be any law that regulates the way wars are supposed to be fought? War is because I have to, I build an army and I'm supposed to go and kill you. So why should there be any laws? In this Venezuela, US, Trump thing, nobody is even talking about the fact that over 50 soldiers of Venezuela, some from Cuba, were actually killed because they wanted to arrest one man. Okay, people are not talking about the war between Ukraine and Russia. Hundreds of thousands of soldiers have been killed. Okay, the Russians are seriously targeting, the energy infrastructure of Ukraine to make sure that they freeze to death. Okay, the issue with Israel, Hamas went in there, they killed. They committed certain, barbarous acts against certain people in Israel. But the return, was it proportionate? So law of armed conflict deals with all of these things, and that is what we turn up to. So without rules governing states' interaction with each other, there can be chaotic. There can be chaos, or wars or anarchy. Okay, and that happened in the First World War. The same thing happened in the Second World War, where human beings were dying because states didn't really have wars that kind of laws that kind of protect certain protected persons whenever war breaks out. Okay, so the law of armed conflict seeks to limit the dangers of a state of anarchy during the outbreak of wars, and they have certain concepts. Ibi Societas, Ibi. There must be regulations. There must be rules are definitely the kind of and there's a Pacta Sanct Servanda, which says that when nation states have treaties or they've set up conventions or kind of agreements, they must always be observed. These are some of the principles of the law of armed conflict. Okay, the laws, regulations bind, compel, and coerce those who are subject to it. Okay. And the choices made by society at a certain moment determine whether society is solely governed by moral or social norms of legal rules are also applicable. These are just, things that describe the law of armed conflict. The law of armed conflict, basically, there's a history behind it. Okay. The history, I think I'll just have to read it to you, and after reading it to you, we'll stop, and maybe tomorrow we'll continue from there. Okay. So let me tell you how this whole law of armed conflict came about. Okay, it says from the beginning of existence until the Middle Ages, fighting was brutal and governed by a few regulations. No one was safe. The conqueror had complete control over how the booty and the hostages of the defeated were treated. And goods and moving objects were fair game. Okay, territories were annexed or otherwise subdued. And they may decide to release or kill people who have been captured, enslave them for personal gain or sell them in slave markets. Okay. The whole history about the law that governs armed conflict started with this Battle of Solferino. Okay. The law of armed conflict was created after the Battle of Solferino in 1859 between France, Sardinia will be Italy, and Austria. Okay. Over 40,000 individuals died as a result of inadequate medical care. So there was a Battle of Solferino, and in a day, 40,000 people were injured and they were dying in the middle of the war, because at that time, they go and meet on a big park and they'll be, using all these spears and arrows, and about 40,000 people were dying on the Battle of Solferino. They were left to bleed to death in the open on the battlefield and in churches. Some of them have been taken to churches to go and just keep them down because there was nothing to care for them in adjacent towns and villages. There was this man, he was a Geneva merchant. His name was called Henry Dunant. Okay. He was moving, he was traveling, and he chanced upon this battle between France, Italy, and Austria in a place called Solferino. Okay. And when he saw that over 40,000 people had been injured and they were dying, it moved him. Okay. And the way that people who had been wounded were moved they were left on the battlefield to just kind of die. He saw it and he told himself, why should human beings, live like this? Despite the fact that we are fighting and whatever we are fighting over, we shouldn't leave our 40,000 people to die without there being some rules and regulations about how warfare is actually, done. So he teamed up with certain local people and started helping the wounded in the battlefield. Okay. So after he left that battlefield, he went back to his place in Geneva in 1862 and wrote a book about what he witnessed in the Battle of Solferino. Okay. And his book provides a vivid picture of the events that took place during the Battle of Solferino. He saw the way he saw over 40,000 people who were actually dying. So Dunant was able, his book, it kicked the conscience of the people around that time to say human beings shouldn't be living like that. Despite the fact that we have war, there must be some rules and regulations that guides the way our wars are waged. So Dunant created two important ideas as a result of his time at Solferino. It was to ensure that service members, that is soldiers, who suffer injuries whilst on active duty receive proper legal protection. His initial suggestion was for nations to formulate an international standard sanctioned by Inviolate in Character Convention. So he says there must be an international law that states that even when we are fighting, there must be rules and regulations. We shouldn't leave 40,000 people to die. Okay. The second one too was that he urged for the creation of national societies to stockpile materials and personnel that will be required to maintain the army's sanitary services and to provide for the sick and injured during times of war and in peacetime. He said there must be an international convention that deals with the way wars are supposed to be fought. And also, when war breaks out, we must have certain bodies that looks after the sick and the injured. There must be medical care for people who are injured during war. And there are certain things that must be allowed and that must not be allowed, even when we are at war with each other. And the whole idea behind it was that we are human beings. We shouldn't kill ourselves like animals. We shouldn't say it's war, so you can do anything that you want, to the extent that 40,000 people would die in a day. Okay. So the book that he wrote, it led to the formation of a 5-member Geneva committee led by this lawyer Gustav Moynihan. I'll give you a book that gives you the whole history. You can delve into it much, much more. The Geneva Committee was able to persuade the Swiss government to call a diplomatic conference in order to deliberate and draft an international treaty based on the work of the committee and Dunant. This led to the Geneva Convention of 1864. And the name of the convention was a convention for the amelioration of the condition of the wounded in armies on the field, which was ratified at the conference, properly realized the essential concept of Dunant's memory of Solferino. So because of the man's book that he wrote after witnessing that battle, they set up a committee that says when there is war, there must be certain rules and regulations that must be obeyed. And that convention, a state that signs up to that convention, even if you are at war, you must wage the war and make sure that the Geneva rights of the combatants and non-combatants are actually protected. Okay. So we will, I think we'll hold on today. Maybe tomorrow we'll find time and finish up with it and look at some of the main concepts in the Geneva kind of convention in here. And I'll forward to you the Geneva. Now we have about 4 different Geneva conventions, and they deal with different. Some deal with people who are wounded in the battle on the field, some in the air, some on the seas, and all of those things. It tells you what can and cannot be done when war breaks out. There are certain concepts and principles that tomorrow we will have a look at, okay, whereby there must be the principle of distinction between, combatants and non-combatants. There must be proportionality. War should only be used when it is legitimate and all of those things. We'll look at some of these principles. Any question?
Any question? Okay, now is the time for me to also ask questions.
Hello, sir.
Yeah, I wanted to ask Manuel a question, but you can ask yours.
So mine is about this convention, this law of war.
Mm-hmm.
Is this to uphold in our modern days, or have they just rejected it on these days?
What do you think?
Because when I look to the situation, the war, the war between the Ukraine and these things, and America and Judge Barrow, nothing's being said about all these things. That's why I'm asking these questions.
The law is
Can I
there.
come in school?
Yeah. Sir Francis, yeah, the law is there. But I can understand why you are asking your question. I really get it.
The law is there, but there are some countries that participate in that Geneva Convention.
Mm-hmm.
So maybe the Ukraine and Russia might not be part. Because there are some countries that they feel that they are so superior to the extent that they cannot form part of that Geneva Convention.
So your assignment for tomorrow is to go on the internet, search for the Geneva Convention, okay, and all the signatories or the signatory country to the Geneva Convention. Okay, tomorrow I'll ask you. That's Francis, oh. Not just Francis, oh. I'll ask anyone. I'll ask Richard. I can ask. Why do you only have your first names? Because there are so many other. Emmanuel to ask you. So look for the signatories to the Geneva Convention. I think it's almost equal to the signatories to the UN Charter. Almost all countries are signatories to it. Almost. But it's the other conventions. That's the Statute of Rome, the one that sets up the International Criminal Courts that some countries are not set up to. But as to the Geneva Convention, almost all countries are signatories to it. Any other question? All right, I think I have another lecture too, and they've been calling me. So, any question?
No, sir.
Okay. So please have a read at the manual. Look at the manual, okay? And if you have any question, the manual, when it comes to this part, it's a bit difficult to read. So start reading it now. And if you have questions, come back and ask me. I'll try and take you through it. Okay.
Yes, sir.
And the main aspect of this part of it, you write your first assessment on it. So it's very vital, and it's objective questions. So if you don't get a small things right, you might not do well.
Yes, sir.
Okay. So tomorrow, I have a class. We're supposed to have a lecture from 10:30 to 11:30, isn't it? Hello.
Yes, sir.
Yeah, at that time I'll have another lecture. Can we do it later on? When do you finish your lectures? Anyway, I'll discuss it with Stephen, your class captain, and I'm sure he will link you up. Thanks for coming, and hopefully we'll meet tomorrow. Have a nice night.
Yes, sir. Thank you very much.
Thank you, sir.
Thank you, sir.
Thank you, sir.